Good afternoon, folks. I'm Luke Swetland with the Museum of Natural History and Sea Center, and I'm delighted to welcome you all to this, our third Lunch and Learn webinar of 2023, presented by the museum's Plan Giving Advisory Council. You know, for over 100 years, the museum has provided education to our community, and we're pleased to offer much of that at no cost, including today's Lunch and Learn program about the role of the trustee and executor in the estate settlement process. To get you warmed up before we get started, I'd like to do a little infomercial about what's happening this fall at the museum and the Sea Center. Tickets are on sale for two great events. The first is the Artist's Table Soiree on Friday, September 29th. Now, this is a dinner event which kicks off the 2-week-long Artist's Table art show and sale, and the sale of that art benefits the museum. About a month later, on October 28th, join us for Creep the Halls into the Abyss. Don't worry, this adults-only Halloween party at the museum is more fun than it is scary, but we will sell out for both events, so get your tickets now. A new Maximus Gallery exhibit called Voyages of Discovery will open Friday, October 13th. This exhibit will showcase rare original illustrations from published reports of some of the earliest expeditions mounted by European science museums around the world during the Great Age of Sail. Later this fall at the Sea Center, we'll be upgrading our wet deck, which is our really fun hands-on science space, and that work will be completed by November 15th. September is Member Appreciation Month, and we're grateful for our 6,200 members, and we're providing a lot of special activities for them this month. Check out our website, sbnature2.org, for details. So there's lots of great things to see and do this fall, and I hope you take advantage of all that your museum and Sea Center has to offer, starting with this program right now. And now I'll turn it over to my colleague, the museum's Legacy Giving Officer, Andrea McFarling. Andrea?
Thanks, Luke. Hi, I'm Andrea McFarling, the Santa Barbara Museum of Natural History's Philanthropy Officer of Legacy Giving. We are happy to share with you this free webinar with helpful information on various appointed roles in your estate plans. Today's webinar is a presentation by Brett Piersma. Time has been allotted at the end for questions. Please place your questions in the chat, which you should see at the bottom of your screen. If you should have any technical difficulties today, please email Robert Shutt. His email has also been placed in the chat. Feel free to reach out to me if you have any plan giving questions or need more information. I am here to help you leave your legacy, and hopefully you will keep the museum in mind in your planning. Now I would like to introduce Brett. Brett Piersma transitioned into the practice of law from a high school teaching career. He attended the College of William and Mary School of Law in Virginia for his degree in law, and is now a partner and the chairperson of the estate planning department at Santa Barbara's law firm of Mullen and Hensel. His practice is concentrated on advising clients on all aspects of planning their estate, including both revocable and irrevocable trusts and gift and estate taxation issues. Brett is also very active in the community, teaching constitutional law as an adjunct professor at Westmont College and community property at the Santa Barbara Ventura Colleges of Law. Brett, thank you very much for speaking with us today. I turn it over to you.
Thank you, Andrea. Appreciate that introduction. Well, good afternoon, everyone, and thank you for participating. It seems like this topic was a really great one because there are a lot of participants out there, and it bears learning a lot more about as you think about your estate. Some of you probably have already done your estate plan, and now you're thinking about some of the decisions you've already made. Others may not have an estate plan and wonder what things should go into the decision-making process, in particular surrounding who is going to carry out my wishes. And so that's kind of why we titled it that. Who will carry out your wishes? And as we like to do whenever we do these presentations, we like to be guided by questions. And so that Socratic sort of inquiry method can help us learn based on the questions that are hopefully in your minds and in a lot of people's minds who are participating today. So we're going to put them all up here for guiding questions, and I'll go through each one one by one. First question is, how are the roles of trustee and executor similar, and how do they differ? What is a executor and what is a trustee? I oftentimes hear my clients ask me, who's my executor? And my answer to them is, well, I can tell you who the executor of your will be, but it's more important, most likely, what you want to know is who's your trustee. These are different roles. They do some overlapping things, and typically you'll name the same person, but we'll get into that. What are these roles and how do they differ, and how are they similar? Oftentimes clients ask me, what are these professional trustees or professional fiduciaries that I've heard of? What do they do? And give me some examples of them, so I may know what who I can pick from in the community. So we'll talk about professional fiduciaries and how they differ from corporate trustees and from individual trustees. Third question we're going to talk about today is, what tasks do the agents under my financial power of attorney and my advanced healthcare directive carry out? Are those agents the same person? Should they be different? What specifically are they going to be doing? And the last question, who should you name for these roles? And should you name the same individual or different individuals? Should you name multiple people? Should there be overlap? All of those things. Well, of course, in number 4, we're not going to tell you who you should name, but we're going to give you pros and cons of all the different kinds of people that you might consider naming. And that'll give you lots more things to think about and hopefully make the right decision. So let's jump off into the first question. And I've decided to sort of start with a 30,000-foot view and say, okay, so what are roles, the different roles of executor and trustee? Well, let's just start with a real basic, simple, straightforward answer. And that is that a trustee carries out the terms of a trust. Well, that seems pretty obvious. It's got the word trust in it. But that's important to understand when you look at the distinction between an executor. People think of the term executor being a sort of broad term that refers to anybody who is carrying out your wishes. But in law, the executor of your estate really is the person who is either probating your will, they've been named as the executor of your will, or if there is no will, then they're carrying out the probate proceeding in what's called intestacy, where a person passes without any will or estate planning documents. So a trustee carries out the terms of a trust, which is usually a much lengthier document than a will, and an executor administers a decedent's wishes in their will. Now, I'm going to talk a little bit more about the difference between probate versus a will that's not probated, and so we'll get into that too, but that's a sort of simple explanation. But now let's drill down into the details a little bit, some finer points. Trustees, what are they? Who are they? What do they do? Well, just some key points to think about. A trustee can serve as a trustee of your trust during your lifetime. So that first hash mark there may serve with the settlor. The settlor is just you, the person who sets up their trust. And so your trustee is likely to be you during your lifetime and during your period of capacity. But if you become incapacitated or you step down for any other reason, the trustee, the successor trustee, may serve with you as a co-trustee or may serve as sole trustee, and you step down from that role. So it's important to understand that you're naming somebody who's going to carry out your wishes, but it's not just going to be after you pass. It could very well be before you pass, and it could very well be for many, many years. I'm going to try to throw into this presentation a couple little insights and things that I've seen along the way from specific client matters. And for example, the second hash mark bullet point, I have clients who become incapacitated and who are completely dependent on others, and they set up their estate plan and they have a trustee who's managing all of their assets. And that, in the cases I'm thinking of, it's typically a corporate trustee. And it can be 5, 10, 15 years. A couple I'm thinking of now are in the 7, 8 year range, but it could be 20 years of incapacity. And so keep that in mind as you're selecting a trustee, that it's not just that they're going to be stepping in when you pass away. They may be stepping in during your lifetime. And if that's the case, then what they're going to oversee will be things like caretaking. and not actually the caretaking, but they're going to oversee the caretaking in terms of making the payments. They're going to handle the wealth management, investments. You may have rental properties, or maybe your home will be rented out to generate income. Well, that trustee is going to be handling all that, signing a lease agreement, collecting the rent, dealing with property management issues and maintenance and upkeep. And so that trustee role could be a very lengthy role, not just a estate settlement or trust settlement period. They'll deal with cash flow issues potentially. If there's high care costs and low income, then they're going to have to figure out what assets to sell, those sorts of difficult decisions. Now, of course, you typically name somebody to be your trustee and you want them to continue being your trustee after you pass away because, heck, you chose them to be your trustee. They must be somebody who's good at this sort of thing. So once you pass away, they can stay in that role. They don't have to. I've set up estate plans where the client says, well, if I become incapacitated, here's who I want to be the trustee. But when I pass, then I want there to be a different set of trustees. It's unusual. It creates some transaction costs and it takes time to transition the person into the new trustee role once the settler passes. But there are reasons behind doing that. And that could be sort of as a check and a balance on the ultimate distribution of the assets, say, for example, in a blended family. So following the settler's lifetime, what's this distribution procedure going to be like? Well, they're going to oversee the distribution of trust assets to beneficiaries. They're going to have to look at the terms of the trust. They're going to have to understand some of their statutory roles, the roles that are prescribed in the probate code. And hopefully the whole process is without court involvement. And we like to think of trusts as being private documents. They're personal and they're private and they're not to be shared with people. But of course, if there's a trust contest and somebody files a petition in the court, well, at that point, the trust will become public. And I don't mean public like it'll be in the newspaper, but it'll certainly be in the court and the judge will look at it. And so if there is no contest and if things go fairly smoothly, then the transactions are all very private. It's between the trustee, the remainder beneficiaries, the attorneys, maybe some financial advisors who are helping sort of liquidate and distribute, but it's not going to be subject to court review. And so that's an important part of trusts and how they differ from wills. Now, that trustee is going to have other responsibilities like accounting. They're going to have to account for their actions. And hopefully those of you who are listening are thinking to themselves, or some of you are thinking, okay, so if I name son 1 and I don't name son 2, then son 1's going to have to account to son 2, and son 1 and son 2 usually get along, but sometimes they don't, especially when they were in high school and now they're, so think about those things. Like if you set up a situation where one son is trustee and the other is not, that could become adversarial. Hopefully it won't, but son 1, the trustee son, will have to provide accountings of financial transactions that he or she took care of, and all of those duties that they have to carry out under the probate code. So there is oversight and there's sort of checks and balances in the code that requires the trustee to take certain steps and actions. Of course, there's lots more, and I'll just wrap up with this, and then we'll move on to executors. The trustees are entitled to compensation. So whether it's your son or your daughter, or maybe it's your son and your daughter as co-trustees, or maybe you name a professional fiduciary, or possibly you might name a bank or a family member, another family member, uncle, aunt, that sort of thing. They're going to be entitled to compensation. Sounds like an accident injury commercial. You're entitled to compensation. Well, they are, and they're entitled to compensation under the probate code. I will have a slide a little bit later that will spell out some of the specifics of what that compensation is, but the code doesn't do that. The code simply says, and most trusts say, you're entitled to reasonable compensation. Well, reasonable changes over time. And so what's reasonable today in 15 years when you pass may be a much bigger number than what you were thinking of now. The reason for that is because trustees have to be incentivized. In other words, they have to be paid and they have to be willing to accept a job as trustee. If you put, and some of my clients ask me to do this, put in my trust that so-and-so is named as trustee, but they can't get paid. I can do that. That doesn't violate the code. It overrules the code in that particular estate. But that trustee is then going to say, well, I don't want to be a trustee if I don't have the entitlement to be paid. And so I don't recommend that unless there's really, an agreement among the family and there's lots of, we've talked about it in detail, because they are entitled to be paid. Now we'll talk about whether they do get paid, if they can waive the fee. Absolutely they can, but the circumstances will be up to them to decide at the time. How many houses am I going to be selling? How long is this going to take? Do I have to file an estate tax return? How many meetings with the attorney do I have to go to? And those are all considerations. The trustee may say, I'll do it, and I'll think about whether I'm going to take a fee when the time comes, because I want to look at how complicated it's going to be. But they are entitled to be paid. Okay, let's talk about executors. Executors are, as I mentioned, the person who is named in a will, or if there is no will, then it's the person appointed by the court to probate the estate of the decedent. Okay, so clearly they're only serving upon death. Once a person becomes incapacitated, in the law, we say that that a will does not speak. A will speaks when the person passes. So the will means nothing at all, when a person's still alive. You can change it, you can revoke it, you can write a new one, but the person who you've named as executor is not the executor at all until you pass away, until the time comes for them to step in. Only serve at death. And that's a key difference with trustees. They may be named in the will, they may be appointed by the court. If they're appointed by the court, they're called a personal representative. And if there is no will, as I've mentioned, there's what's called intestacy. And so they are a personal representative. And the probate proceeding carries out as though the person left an estate plan, and that estate plan is located in, if you have no will, it's located in the probate code. I can talk more about that later if anybody has any questions, or you can send me an email. But I always tell my clients, and it bears stating here, that you may not have an estate plan, but the state of California has an estate plan for you. And that estate plan is right, I've got it right there. My probate code is always right behind me, my copy of the probate code. The probate code includes language on what to do with the person's assets when they pass away. And they don't pass to the state doesn't automatically get them if a person has no will or trust, as a lot of people think, but the assets are governed by the terms of the probate code. And so if there's no will, they're a personal representative, but what do they do? If there is no estate, so let's say there's no will and there is no estate, meaning there's not really any assets. All there are, let's give a hypothetical. Let's say there's an IRA, a retirement account. And on their IRA, the person has named their daughter as the beneficiary. And that's the only asset in their estate, right? Except for, they were receiving Social Security, that sort of thing. There's no need to have a will, and there's no need to have an estate or a probate, because all the assets, the IRA will pass automatically to the daughter, and there are no assets that need to be probated. And so an executor is only appointed, so they're named in the will, but they're only actually appointed in a court when a probate is needed. Otherwise, their name on that will that says, I've named so-and-so as my executor is largely meaningless. There's nothing for them to do, okay, in some circumstances. Now, the circumstances where they are needed will be if there are assets that are supposed to be in a trust, and there is a trust, but the asset never made it in the trust. Like, let's say you had a brokerage account and a house. You set up a trust, you talk to your attorney, but then you never put your assets into the trust. And you also have a will. That will probably have what's called a pour-over provision. And that pour-over provision will say, all the assets in this person's estate need to be poured over into their trust the way it was supposed to be. Okay, that pour-over will now needs to be probated. So your executor now springs to life, comes to action, files a petition for probate. They're appointed as the executor, and the person's will is probated. At the end of that probate, which is at minimum 9 months to a year long, maybe longer, typically longer, though the assets in the decedent's name will then be transferred into their trust if they have a trust. So you can see that's an example of you've named somebody to be the executor, but if there isn't anything to do, then they don't ever step into that role. If there is something to do, it largely is going to require a court action, a probate, or some other type of court action. They're entitled, so let's talk about what they get paid. a executor will get paid statutory compensation. Again, statutory meaning it's in the code over my shoulder. It's in the probate code. They get paid based on the value of the estate, based on the value of the probate estate. So let's say you have some property in a trust, and then you have a house that you left out of your trust, and that's going to be probated. That probate will be based on the value of that house. And the statutory fees are tiered. They start at 4% for the first 100,000, then they step down to 3%, then 2%, then 1% as the value of the estate goes up. So for a roughly $1 million house or $1.5 million house, you can have something like $30,000 or so worth of probate fees, to which would be paid the executor. And so that is off the top. Even if the work costs more than that or takes less than that, that's a statutory compensation. They also can get paid for extraordinary services if they do above and beyond. And they just have to file a petition in the court and say, hey, I get paid this statutory fee of $30,000, but I also get paid this extraordinary, this fee for my extraordinary services because I had to negotiate a creditor claim. I had to sell a business or sell a product, or whatever the extra work was that's different and above and beyond, so to speak. So executors' jobs can be pretty complicated if there's a estate to probate. Last point on executors and wills is that for some of you, your estates are large enough to require an estate tax return upon your passing, or other types of tax elections. You may have an estate plan that calls for, after the first death, an A and a B trust, right? Or an A, B, and a C trust, or a tax exclusion trust. Maybe there's a Q-tip marital trust and a survivor's trust. The executor on the estate tax return for the first spouse to die will have to file and make certain tax elections. And among those tax elections could be the marital deduction. There could be a Q-tip election. There could be other forms to be filed. So the executor is the one who signs those forms and those documents. On the second death, if there's an estate tax return, that's who's signing it. But that's really just a signing thing. You're not the one preparing it. You're hiring an accountant to do all of that. Okay, so that's executors for the most part. Now let's get into our second question. All right, so we know what trustees are and we know what executors are generally. What about who should fill these roles? Let's talk about this class of people or group of people known as professional fiduciaries. This is a relatively new profession, I'll say. In the last 15 or 20 years, professional fiduciaries have really grown in popularity. A lot of families really like them. And the reason why is because a lot of families just don't have someone in their life to do all of this work, and they just don't want to hire a bank or a trust department at a big bank, because that's much more expensive. So the professional fiduciaries kind of slot in between naming your son or daughter or your cousin and naming, Wells Fargo Bank, right? Those are very different people. Wells Fargo Bank professionals versus your family. Professional fiduciaries are in between. They have more experience, more depth and breadth of knowledge, but they charge a lot less than a bank, but more than your cousin, niece, nephew, daughter, or son might charge. What are those fees? I asked a couple of them that I work with in preparation for this presentation, and currently the rate is about $200 to $300 per hour. But most professional fiduciaries have support staff, and they charge their support staff out at less than that. Bookkeeping, those kinds of things. So they're between $100 and $150 or so for the support staff. Seems like a lot of money, and it certainly is. But if you look at the rates from banks, it can be a lot less, or just depends on how much time is being spent. These professional fiduciaries are typically certified from the PFAC, the Professional Fiduciary Association of California. You can go on their website and look up names of these individuals. They have to maintain their license. So it's nice that you're getting somebody who has this formal training and understands fiduciary duties and the fiduciary roles, and all of that they're getting, what they're getting paid for really gives you this ability to handle more complicated administrations than just your individual family member, right? Especially if you have a small business that needs to be liquidated, or an S corp, or let's say you have an apartment complex that has very low basis and is generating lots of income, and you become incapacitated. Do you want your son or daughter handling the management of that property or your business for years and years while you're incapacitated, or to handle the sale after you pass away. And so these professional fiduciaries can really be great where there's a complicated set of facts and no good family member to carry it out. They usually have local offices. They don't have offices around the state, right? Usually professional fiduciaries are a single office with a handful of fiduciaries in the office and not multiple branches around the state. Okay, but they do oftentimes have multiple fiduciaries and support staff within that office. And again, these are perfect choices, these folks, for those of you without qualified children. And when I say qualified children, I just mean children that you don't think are really well equipped. They're qualified because they can be a trustee. There's nothing that prevents them from it in the law, but they're just not quite equipped with the talent, the interest, the skills, the time. Oftentimes and I have this conversation with my clients very often. Gosh, my son would be great, but he is just so busy with his career and with his family. He's got 2 young kids, that sort of thing. Or the same thing, my daughter, she's just started a business. She's an attorney herself. Naming your son or daughter in this role may feel like you're giving them a great honor, but it's a lot of work. And so I had this conversation just recently with a client, and he just did not feel like his children, great as they are, will be able to, just from a time perspective, handle all of this, and things could fall through the crack. And so he really wanted to explore a professional fiduciary, and we worked with him on that. And so these folks are the perfect slot right in between. Now, what I'm going to do here is just real briefly put up on the screen the names of some professional fiduciaries here in Santa Barbara. These are not people that the museum necessarily endorses or that I endorse, but these are folks that I know and I've worked with and I've had a great experience with. There are others in town, and the museum, I think, has a list of even more folks in town that you could ask. You can go to the website or email us and we'll send you a list. These are just some folks that came to mind that I've worked with recently that I really enjoy. Impact Family Office, Kaya Jordan is the head of that office. I think he started that company several years back. Quinn Fiduciary Services, Jackie Quinn and her staff, and she has a handful of fiduciaries in her office as well. Channel Islands, I've worked with Courtney DeSoto quite a few times, and Sharon Kennedy as well. Again, these are not the only 4, there are others, but these are all folks that I think would be great. And what I oftentimes do is I recommend that clients, I'll give them the names and contact information for these folks or others, and I'll say, go interview a few of them. Tell them what you have as concerns. Tell them what your assets are and why you don't want to name somebody in your family and why you're exploring a professional fiduciary. And after interviewing 2 or 3 of them, make your selection. And they'll do that. Kaya Jordan will go have coffee with you on a Tuesday afternoon, or you can go down to Jackie's office and meet with her and her staff and get a feel for what they can provide to you services wise. And then you can make your choice. And that's a really great way to do it, because that way you feel confident, you feel informed. You're not just going with the attorney's recommendation. Now let's talk about professional fiduciaries and corporate trustees and how this next level of trustees compares with professional fiduciaries. A corporate trustee is not a professional fiduciary per se, because they're not licensed by the Professional Fiduciary Association, but they are fiduciaries. They fill a fiduciary role as a trustee. And they're also very professional. I mean, they're professional in the lowercase p sense, that they know what they're doing, and they're very technically excellent, especially some of these really great banks and trust departments. Now, what you get with this service, you pay a premium. It really depends on the value of your estate, but the range is a percentage. It's not an hourly rate. And that percentage is somewhere between 0.75 and 1.5. Oftentimes they'll tier it. So you'll pay 1.25% for the first 500 or maybe $1 million value. And then it'll step down, 10 basis points or 25 basis points as you get to the next million, the next 5 million, the next 10 million, that sort of thing. So some of you may have estates in the $5 or $10 million range, and you would want to talk to a corporate trustee and say, what would it cost if the value of my estate is this? And they'll run it through their calculator and they'll say, here's what we would charge. The charge is oftentimes either annual, if there's ongoing administration, 1%, 0.9%, something like that. And then at the end, once you pass and they're just distributing, it's usually a one-time estate settlement fee of about 1%, something like that. So those are corporate trustees. They're almost always associated with a bank, not always. Sometimes they stand alone. They don't have banking services. Sometimes they're associated with other financial institutions or an investment like a brokerage company. Okay. And so you can kind of package, you can pair the services. I'm going to get trustee services, but I'm also going to do all my investing with them, or my trustee is going to do all my investing. So they're going to hold my $2 million investment portfolio or $5 million investment portfolio, and then they're also going to carry out the terms of my trust. They can handle very complicated administrations. We had one recently where property all over the country, right? If they have offices, if you choose one of these banks that has office locations and staff all over the country, then we're going to be able to sell that apartment complex in Missouri and that, those 4 homes in Texas, and then also your home on the Riviera here, and handle your portfolio of investments as well. And so they can handle these more complicated transactions where the assets are all over the place, diverse in location, character, all of that. As I said, they have offices usually around the state or country. Oftentimes we come across this issue in our little town of Santa Barbara, right? Little no longer. But we have some great professional, some great banks and organizations here in town, but we also have some that don't have a trust office or a trust department here in Santa Barbara. Their nearest one is Ventura, Camarillo, Los Angeles, Century City, or up north, San Francisco. And so in those circumstances, you don't have somebody local that you can go to who is your trust officer associated with that bank. And that can be kind of frustrating for some people. So you may have a great relationship with a great bank like BNY Bank or something, but they're not going to have a local department to do a trust settlement. They don't have to for you. It's really up to you. It's a preference thing. If you want there to be an office that you can walk into, then that should be one of your considerations as you choose. Again, I'm going to give a list of corporate trustees that I've worked with, some organizations that I think are great here in town. Northern Trust down in Montecito. I work with a couple of their trust officers. City National Bank is also in Montecito. Farmers and Merchants is right here downtown in Santa Barbara, and their trust department. Montecito Bank and Trust has offices around town, and San Pasqual Fiduciary Trust is here. I think they're downtown as well. So again, there are more, and I don't want to leave anybody off that I've worked with in the past, but these are just the ones that came to mind that I really like. And they also have local presences that I really like. And again, there are others that don't have a local presence that are just as professional and wonderful, but they're not here in town. Sometimes I've worked with some where they're willing to come to town and visit periodically, like they have an office in Camarillo and their trust officer comes up every quarter. So every 3 months they're up here and they're visiting all of their clients. So that's a possibility as well. Okay, quite a bit. We have about 10 minutes or so left. For the next 2 questions, I'm going to answer, we're going to switch a little bit over from the trustee executor world over to the other 2 important documents in your estate plan: power of attorney for financial matters and your advanced healthcare directive. Well, what do these people, the people that you name, what do they do? What is their role and their tasks actually look like? Well, the code, and I always hesitate to put too much text on the screen, especially when it's the probate code, which will quickly make your eyes glaze over. But the probate code states that for powers of attorney for financial matters under 4000 of the California probate code, you're the principal. You get to name an agent and you get to give them the power or restrict the power for anything that is legal that you see fit while you have capacity. The power can become effective immediately and then continue upon your incapacity. So they're effective now, but then once you become incapacity, they're durable, so they stay effective. Or they could become effective only upon your incapacity. And then at that point, continue on. But again, all lawful subjects and purposes, anything that's legal for you to carry out, you can designate to an agent under a power of attorney. Now, let's look at healthcare directives. California has a really great section in the probate code. The legislature has this introductory paragraph that describes healthcare choices. And I've always found this an interesting aspect of this profession, where I spend so much of my time with my clients talking about finances and money and estate taxes and fiduciaries and all that. And then we get to the time where we talk about healthcare, end of life decisions. It's such a personal thing. We go from handling your money, which is also very personal, to now end of life decisions. It's very heavy and weighty. And so naming an agent in that role is a tough choice. And there's a lot to be considered. The probate code, again, this is 4600 of the probate code, states a couple basic things about California's rules on healthcare directives. Every adult, and this is sort of a paraphrase of 4650 subparagraph A, every adult in the state of California has a fundamental right. And if you're a constitutional law person, you know fundamental rights is a loaded term, or a very important term under the Constitution. But in California, you have a fundamental right to control your decisions related to your end of life, your health care, treatment, all of those things. Okay, fundamental right. And as part of that right, you have the right to name somebody to carry those out for you and to express in a document, here are the decisions I want made. Sustain my life, don't sustain my life. If I have a terminal illness, I want life-saving treatment, I don't want life-saving treatment. All those kinds of decisions. That person then is going to consult with physicians. They're going to consult with family members. They're going to look at the record, in other words, your medical record, and say, oh, this person has struggled with this illness for many years, and this is sort of the natural progression of it. And so they're going to see those things. They're going to be talking with the doctors. The doctors are going to be giving them candid information about your condition. They're also going to be making decisions about the disposition of your remains. Now, you can say, I want my ashes sprinkled at Anacapa Island, and then they're going to try to do that. Of course, that's illegal. So they're going to struggle with that. And so maybe they're going to, you know, if you say, I want my ashes spread over the water, that can be done. So they're going to have to make those decisions or carry out the decisions that you've made. And I've had clients tell me, okay, I understand that my decision here can't be carried out legally, but I want my agent to try. And if they can't, then they can do what they want with the remains. So those are the kinds of things that they have to wrestle with. Okay, couple key points on who you should name and some considerations that should go into this process. Well, of course, you're going to want to name somebody who is effective and who knows the family, but you may also want to name somebody who is the same person for multiple roles, for, let's say, for trustees and executors. So let's start with just trustees and executors. If a person's going to have to file a petition in probate and also carry out the terms of your trust, might as well make the same person. If it's going to be your daughter, let's make it your daughter for both. If it's going to be a professional fiduciary, put them for both. There's no reason to select somebody different for each of those roles. Fiduciary duties place the trustees in an adverse relationship to beneficiaries. So that's a consideration you may want to really think about. I was just talking to a client recently, and we said, okay, let's name this professional fiduciary. And I said, this professional fiduciary in particular is great at resolving conflicts among people. And the people we were talking about, the client's children, have some conflicts. And so I'm thinking, okay, I don't want to name one of them as, I don't want the client to, and the client didn't want to. Let's name somebody that we know can sort out these adverse, the relationships among the kids. As you consider, I've talked a lot about the tasks that they're going to do, that they're going to carry out. They don't need any specialized knowledge. Sometimes my clients say, oh, well, my son, he's an investment advisor, or my daughter, she's an attorney. That's great. They don't need those skills to be a trustee. They just need the ability to manage. They need organizational skills. They need time management skills. They need to be able to consult with professionals and hire professionals and oversee those professionals. The trustee is not required to have detailed knowledge of stocks and bonds or the real estate market or rental property. They don't need that. They need to know how to hire people to carry those things out, people who can do those things. So that's really the skill set that they need: organizational, time management, ability to manage relationships with hired professionals, as ability to handle when your son or daughter calls the trustee and complains about the most recent distribution check. How do you handle those kinds of situations? So those are the kinds of skills that trustees and executors should have. How about agents for power of attorney and for financial, or for power of attorney for financial matters and for healthcare directives? Your financial power of attorney agent should really be the same person, and not always, but I usually recommend that they be the same person as the trustee and executor. It just makes administration a lot easier when you become incapacitated to be able to sort of muster all the assets, get everything into the trust, pay the bills and all of that if it's the same person or persons. Now, the healthcare directive, different set of considerations. They have to make tough choices. They have to oftentimes be dealing with making a decision while there's lots of emotion and lots of difficult, feelings, because it's a tough time for the family. Now, let's talk about, should I name multiple people? You should probably name one individual and give that individual, especially for a healthcare directive, give them the full authority. Now, some people say, well, what if I name one individual, but that daughter has to consult with my two sons before she makes the decision? Great, you can do that, but the daughter is the agent. She has all the power. So that's option one, and option two are kind of my preferred approaches. Sometimes clients say, no, it's got to be both of my daughters. I can't have one and not the other. Okay, we'll do that. And they have to act unanimously. And if they can't act unanimously, then a decision won't be made because they both have to. And that can be a tough one. Last one is, okay, well, what if we have more than two? We have three. Let's just make it by a majority decision. That works too. It's not preferred because it does set up that situation where now all three have the right to make a decision for healthcare, for end of life, or pull the plug, don't pull the plug, those kinds of things. And one dissents and the other two agree with the decision. And then now the decision is made, and that one child feels really, feel really bad about that decision. So those are some things to consider. Final slide, and then we're going to get into some Q&A. I want to just kind of give you a quick picture and a bullet point list of here are the fundamentals, the fundamental pieces of a well-structured estate plan. And I talked about these already in the presentation, but kind of summarize the whole estate plan. Now that you've got all this information about who do I name, agents and trustees, you should have a trust, most likely. If you have any assets whatsoever other than just IRA beneficiary designation type assets, you should have a trust. You'll need to have a will or wills for the two of you. Power of attorney documents, of course, for financial matters. You're going to need healthcare directive forms filled out. You're going to need general assignment of assets that transfers all of your tangible personal property into the trust. You're going to need other transfer documents like a deed, and you're going to need to fill out beneficiary designations for any of your life insurance or retirement accounts. You don't need to have a diagram, but the diagram makes it easy so that in 5 years you can look back and open the binder and just look at the picture of your estate plan, and that guides you versus having to flip 2 pages and understand exactly what it says. So this diagram kind of just shows you a snapshot. If you had husband and wife, 2 sets of assets all in one trust, things pass into 2 trusts, could be 1 trust, could be 3 trusts, decedent's trust, survivor's trust. And then upon the second death, assets pass out to the children. There's IRAs, there's life insurance. So that's kind of what a picture of a good plan looks like. There certainly can be more aspects to it, and there could be fewer aspects to it if the plan is a little bit more simple. And our last slide is 12:47. So I think I hit us just a little bit over time, but we have plenty of time to do some Q&A. And so I'm going to put that slide up. Again, my contact information is up there. So is the museum's, and there's some other information about our next Essentials workshop. And at this time, I'm going to kick it back over to Andrea to moderate the questions.
Fantastic. Thank you so much, Brett. What a wonderful presentation and a lot to think about. I have received a number of questions, and I also created a few myself. So I'm going to kind of jump back and forth because I think a lot of what's in the chat is also some of the things that I think are pertinent information that we jotted down in advance. First off, which agent is actually the one authorized to deal with burial or cremation services? I feel like you touched upon this, but just to clarify that point, what happens if there's no appointed agent for this? That would be the second part of that question.
Yeah, that's a great question. The agent, so if you name multiple agents and they have power that's concurrent, then they all have to decide, okay? If you name one agent followed by a second agent in case the first agent can't serve, it's whoever has stepped into that role. Oftentimes a person will be named and they'll say, you know what, I decline to serve. either as trustee or as agent under the healthcare or power of attorney or as executor, you can always just decline to serve. So if a person declines to serve, it goes to the next person in line. That's the one who has decided to act. They're the ones responsible for the disposition of remains. Now, I'll add to that, that if you write down on your healthcare directive, or if you talk to your attorney and they put it in your documents, and you say, I want to be buried here, I want to be cremated, I want this to happen, then the agent is just carrying that out. They're just carrying that wish out. They're not making their own decision. It's only if you leave it blank that now that agent has to make the decision. So it's either agent's deciding for you or agent is just doing what you said to do.
Okay, thank you. So in our chat, and this is similar to another question we had talked about, with regard to a child who is acting as the trustee, would you recommend a payment for this trustee and that type of approach? Most siblings, where there is one of the sibling that is the appointed successor trustee, and they are also named as a beneficiary, in many regards, they're there to protect their own interest in the inheritance. How have you seen siblings react to payment for one sibling that is the trustee, and how do you approach that issue?
Mm-hmm. Yeah, the first way I approach it is to advise the client. And at that point, the client is typically the child who comes in to say, so-and-so has passed, and I'm now named as the trustee. And I'll advise the client that they're entitled to pay themselves a reasonable fee, and I'll advise them what that fee is. And then I'll sort of put a little asterisk next to it and say, but any fee that you take will be taxed as income. And so if you take money from administering the trust, you're going to get taxed on it. If you don't, and it comes to you as part of your inheritance, you don't get taxed on it. So that's kind of a pretty easy answer for some, unless you've got 5 beneficiaries and you're the sole trustee sibling. I'm the 5th of 5 in my family. So, and I'm going to be named in my dad's trust. So I think about what my relationship with my older siblings is going to be like. And so just as an aside, but the point is that if I take a fee, then it's coming out of my own share as to 1/5, but also as to my siblings' shares as to 1/5 each. So it doesn't reduce my share of the estate very much, but it does expose me to a little bit of tax that otherwise wouldn't be. Now that's on one side. The other side of it is, what's that going to do with my relationship with my siblings? I'm going to say, hey, siblings, my attorney said I can get paid for this. This is hard work. This is a lot to do. I'm paying myself a reasonable amount. Those siblings may say, great, we're so glad you're doing it. We don't want to do it. And God bless you, get paid. But they may say, you always had a relationship with dad that was closer, blah, blah, blah. You just never know. So I advise the client to really think about that. But again, it's not up to you as the settler. This is up to your kids to decide if they're going to get paid and if they're not going to get paid and what it's going to do to their relationship. Last comment I'll make about that is, nobody likes to do a lot of work for other people for free. People do it. And most clients of mine who don't take a fee, it's not a tremendously difficult administration. So they got a few meetings with me, a couple of emails. It's a couple hours a week for 2 months. They're going to do it for free for the family. But if it's really complicated and they're spending hours and hours and hours, and it's years and years, and they're thinking, I'm doing this all for my siblings so that they can get the estate and just go on with their lives and not have to do any of it. So that's a consideration.
Yeah, thank you. Is it wise to name a backup person to serve in these various agent roles? And in case the first named person is unable to serve, and should I name 2 backup people? What do you suggest on that?
Yeah, I recommend that you at least name 1 backup. So you name an individual and you name 1 backup. You can name 2. You can name as many as you like. I don't think you need to go beyond 2. But at the minimum, I would say name 1 and 1 backup.
Great. Does the healthcare agent assume any of the medical debts of the person they are representing?
No, and that's a great question. The debts of the person are handled separately through a creditor's claim process. But the person who made the end-of-life choices or opted for a treatment or called the paramedic, that person, that agent, is not liable for any of the person's debts solely because they're the agent.
I am the, see, I can't see this whole thing. I am the executor individually of my parents' wills and trusts for their respective trusts. Sounds like their parents are divorced. What are the potential legal issues as trustee executor can face if my other siblings have a dispute with the terms of the will/trust?
Yeah, if there's ever a dispute about the terms of the trust and the settler of that trust has passed away, then your responsibility, and this is an important one, your responsibility as a trustee is to be neutral. And that may be hard to do. And I've been in court with this argument before, both on my side and the other side, where if my client is the trustee and a beneficiary, and they stand to benefit from a certain interpretation of the trust, that they would not benefit if the trust were interpreted differently. Or if there's some question, oh, did dad have capacity to sign that amendment, right? The trustee needs to be fair and neutral and cannot act in their own interest. And so the exposure there is the potential that your siblings or step siblings or whatever it might be might say, you're not qualified and I'm going to file a petition to have you removed and have someone neutral appointed as trustee. And that's just a potential. It's always out there and there's nothing really we can do about it except to make sure the documents are clear and up to date and that the client, the settler, had capacity when they executed it.
Okay. And then here's a number of interesting questions I think that all relate to the trustee. With property owned as tenants by the entirety, is the value included in the probate estate? There's number one.
Yeah, I'll answer that one. So tenancy by the entirety is not a California concept. So California has something different. And I think that property probably is out of state, or it was done by an out-of-state attorney who titled it that way. We have tenancy, we have joint tenancies, we have community property by right of with right of survivorship, joint tenancies, tenancies in common, but tenancies by the entirety don't exist in California that I'm aware of, or they shouldn't. They're interpreted differently. So the other question then is, well, what is it included in their estate if you have something titled that way as a joint account or a joint asset or a tenancy in common? And the answer is yes. If you have any asset in your name, it's in your estate for estate tax purposes.
Yeah. And interesting, because then the follow-up question to that is, does the trustee or executor need to be a California resident?
Great question. They don't need to be, but what this brings up is the potential where if we had a trust contest, the trust is technically administered in the jurisdiction where the trustee lives. And so if you're in another state, we don't really have jurisdiction in California to file a petition in a trust matter. Now, your probate estate will happen in the county where you lived when you died. The law that applies to your trust will be the law that's stated in the trust instrument. So it could be a California trust that's actually being administered in a trust court in another state if you're if your trustee is in another state. So it gets complicated, and I don't recommend it. We can work around it, especially if there is no trust proceeding, if there's no contest or anything like that.
Yeah. Most people have not put their personal property in the name of their trust. So would it be the executor of the will that deals with distributing or disposing of personal property?
Mm-hmm. Yeah, that's a great question. So personal property does not have a title, formal title. Your house does, your accounts do, but your leather couch does not. And so what we do is I'm going to go back to this slide here. In my estate plans, this fifth document, the general assignment of assets, that is sort of a magic wand that says, I want my jewelry and my watch and my clothing and my leather couch to be in my trust. I'm generally assigning it all. I'm assigning all my tangible personal property. So when that document is signed, now the trustee can handle those and manage and distribute them. And in their capacity as trustee, it does not require the will to be probated, and the executor of the will does not have to take any action.
Thank you. Excuse me. There was a question about having a copy of that flow chart, and all the slides will be sent to all the participants today. So yes, that you will have access to Brett's wonderful slide. So I think we have a couple more minutes, and I see a lot more questions in the chat. So let's see if we can get to a few more of those. Are there independent agents that can be hired to be medical powers of attorney and be briefed by me about my specialized medical needs to better understand my advanced healthcare directive?
Great question. I've done something very similar to that, where a client the short answer is yes. And the longer answer is we can work with you, or your attorney, if you have an attorney already, can work with you to design a healthcare directive that is comprehensive and that includes detailed explanations. And once you've sort of worked out the details with your attorney, you then sit down with the named agent and walk them through it. Again, you're going to want to be careful, though, what you share, because your personal healthcare information is private to you. So if you share it with your agent, you're disclosing personal information, which is, of course, your prerogative to do. But yes, that can be done. And the agent, they'll sit down with you and go through all of your wishes and do a Q&A sort of thing. I've done that with clients before. It's great. It really makes sure that the client feels comfortable knowing that this team of people or this individual knows everything they really need to know to make decisions for me.
So here's an interesting question, and it's talking about their mother who is moving into dementia and is not really able to do any of this. Is there any advice you'd give on how to set up some of these different trusts and name different people, especially if someone is entering the world of dementia?
Yeah, and by the way, Andrea, I'll be happy to go a few more. We're at 1 o'clock. I'm happy to go a few more minutes. We can do maybe 1 or 2 more questions after. If people are still on, it looks like there's quite a few people still on the Zoom here, so that's fine. Yes, if a person is beginning to develop dementia, it does not mean that they are incapacitated yet. But of course, incapacity is probably in their future. And so what I'd recommend is first to see if they do have capacity and what level of capacity, because it's a spectrum. You don't go from having capacity one day to being incapacitated. Most people don't. And so what I would recommend is if she has capacity, and maybe it's limited, maybe it's just enough capacity to say basics of what she wants, then get some documents pulled together. And you're going to have an attorney make that assessment with her doctors. If she is completely incapacitated, then the options to you are what's called a conservatorship, which is what's filed in a court, where the court makes decisions, appoints somebody to make decisions for them, oversees those decision-making steps, and then does sort of an estate plan for them during their complete incapacity.
And I'll take this as our last question, because this will be a great segue into our estate planning essentials workshop. What if our father is not wanting to talk about any of this, anything related to this? How are we going to know any of this information he won't tell us?
Wow, that's a doozy. I do wrestle with this issue with clients quite a bit, but the fact is that a person can't be forced to do an estate plan. And if your father doesn't want to, he doesn't have to. There's no rule that says you have to have an estate plan. It just means that if he becomes incapacitated, you're going to have to deal with that situation: no estate plan, incapacity, assets titled however they're titled in his name, or joint owners, who knows. And then if he dies, when he dies, then you'll have to handle a probate. It'll be a probate estate. What you might do is talk to an attorney about what does a probate estate look like? Where would assets flow if a person dies? Married, not married, 2 kids, kids from prior marriages, that kind of stuff. Where do the assets go by default through a probate? And that attorney can tell you. It's in the probate code. The short answer is, again, it's not going to go to the state. The state's not going to take all of his assets, but it will require probate, and that's going to be expensive, time consuming, but they happen and they work and they come to a conclusion and the assets go where they go. It's just not as efficient as it could have been.
So thank you, Brett. Really appreciate all your time and your expertise. The museum's Plan Giving Advisory Council is hosting our free estate planning essentials workshop on Sunday, November 12th from 3 to 5 p.m. at our Mission Creek campus. More information will be sent as we get closer to the date, but we hope you will join us on November 12th as we dive deep into all the aspects related to estate planning. And if your parents won't share with you or don't have an estate plan, we hope that all of you will consider making your own estate plan. And November 12th on Sunday is a great workshop for you to attend to get some important information on how to make that happen. I think we all can agree that we are thinking a lot more about our various appointed roles and estate plans. And Brett, thank you so much for all you've provided. And we hope that all of our participants, as you begin to think about who you're appointing in your estate plans, and as you create your legacy giving, that you consider including the museum in your plans. And I'm always available to help, and you can see on the screen that we have both Brett's information as well as mine. So thank you, Brett. Thank you to the museum's Plan Giving Advisory Council for helping us to coordinate this presentation. And thank you to all who attended. Have a wonderful day. Thank you all.